Hello and welcome to That Fine Bachelor's Law. In this episode, we have Botswana Doctors Union. For the past 2 years, there's been an ongoing conflict between them and the government. Today, we are here to unravel the legal issues surrounding this matter. Allow me to welcome the president of Botswana Doctors Union, Dr. Selema. Welcome to the episode, sir.
Thank you very much for having us today.
Thank you for honoring me with your presence. I think first let's start here. Give a brief introduction of who is Botswana Doctors Union and what do you do?
Botswana Doctors Union is a union of choice for doctors, be medical practitioners and dental practitioners. It was duly registered and recognized from 2019. And we hold a recognition agreement with the government of Botswana through DPSM. So we entirely represent the doctors across the private as well as the public sector. In our representation of the doctors, we talk of their welfare, conditions of service. Of course, we do negotiate their salaries, and we also do health reforms for the government or with the government to try to improve how the healthcare sector should be viewed as.
We have several trade unions in the country that are considered major. Why did you find it opportune to create your own or specialist trade union instead of joining what one would consider the mainstream or the major trade unions?
We believe that for the longest while we were not understood. We have a lot of doctors in other unions. And for many years, our issues were not raised the way we understand them.
Yeah.
And therefore, there was a misrepresentation of our issues.
Yes.
You must recall that in 2013, after the 2011 national strike,
yes,
there was a court case between the Botswana Junior Doctors Association as well as against the DPSM.
Yes.
Still regarding the same issue, especially of emergency call. That issue then made us to realize that unfortunately we are still misunderstood, and the conditions of how we work, they are not understood. It was from there then that we sat and realized we may need a union instead of an association due to the powers that the union would have over an association and due to a perceived lack of understanding from the so-called major public sector unions.
So, as you put it, as we move forward with our conversation, this rift surrounding emergency call goes as far back as 2013.
Yeah.
Can you break it down for us, where it started and how we got where we are today?
So in 2013, actually before 2013, because the matter was actually finalized in 2013 by the courts. So before then, doctors were among the public servants who actually went on strike. And we do have doctors who were fired from there.
Yes.
Some were reabsorbed, some were never reabsorbed. And they left to South Africa and the other countries. So the outcry was that doctors are working exorbitant hours.
Yes.
That are unrecognized and uncompensated.
Yes.
And you could imagine how many doctors there were in 2011.
Yes.
Quite a few, honestly. Then the matter was referred to High Court, and we did have a legal representative there.
Yes.
When we referred the matter. The outcome was that doctors should actually now take days off in lieu of payment. Mm-hmm. And then doctors started doing that, taking days off in lieu of payment. Then the doctors did realize that it was impractical for them to continue taking days off. It actually now made the system non-functional.
It paralyzed the healthcare system.
It essentially did paralyze it.
Yes.
So you can take an example and say, if one doctor does like 5 emergency calls in a month,
yes,
which are 24 hours,
yes,
then you would say that is 120 hours of overtime or of emergency call.
Yes.
In a normal month of 22 days, a doctor would do 176 hours.
Of
like from 7:30 until 4:30.
Of the
any
emergency
worker.
call?
No.
Oh, yeah,
Just
okay.
any work. Yeah, who is working like 22 days in a month
Yes.
as a pay cycle.
Yes.
Then they do 176 hours in total. That is 8 hours by 22 is 176.
Yes.
Now you have a doctor who is doing just 5 emergency calls and they do 120 hours.
On top of the 176.
Yes, on and above that.
Yes.
So then that means then how many days off are you going to give that person? You just have to divide the 120 by 8 hours of the day that the person has to work. Then pretty much the person is out for like 3 weeks.
My math is not good. I was going to say the person will be gone for a month.
Yeah, or be almost gone for the month.
Yeah.
Now imagine, you have 5 doctors there. Two are gone for the month. Not even, leave or anything. No, just days off.
Okay.
So in a sense, you'll be left with 2 doctors. So we sat again as the doctors and said, you know what? We're actually killing each other. Let's just, try to take the most minimum wherever we can. We even lost track of the days off that we are owed. Until now, we started realizing again that no, this is now a killer because people are not resting enough and people are actually now not happy even with the system of payment. Okay. That's where now it raised again to the issue of the union being formed.
Now let's fast track to 2023 when the negotiations took place. My understanding is there was an agreement that a 15% commuted emergency call allowance will be paid on the condition that 3 things will be implemented. Yeah. Can you take us through those things that were agreed upon in 2023 on top of the 15% commuted allowance? I understand there was a policy and some contracts that were supposed to be concluded between yourself and the government party.
So in fact, before 2023, the negotiations started in May of 2022. Those were salary negotiations and conditions of service.
Yes.
For the doctors, because we do have a lot of so many conditions that we wanted to discuss, we only picked out one as a priority because we had 2 other unions that we were forming cooperation with. And we named 3 cooperating trade unions, that is DAU and BDU.
Yes.
So we started negotiating for call. Government initially did not want to acknowledge what call was. They said they don't know that we're working that, it's our own doing. And then from there on, they formed a task team to say, go and look if indeed there's anything called a call. The task team was to inform now government even on remuneration. This was a task team that was formed at the negotiation table.
Just to be clear, in 2022, the DPSM, as the employer, was alleging that they are not aware that doctors are being called on emergency call.
Yes, exactly. So even the DPS, or Deputy Permanent Secretary, Health Service Management, had to be called to come in and testify if at all there was anything called emergency call. And then he came and clarified it for them that yes, there is that, and it is part of what these guys are doing on a daily basis.
Okay.
So then that task team was formed, and in September of 2022, it was comprised of Botswana Doctors Union, Ministry of Health, and the DPSM.
Yes.
So the task team came with recommendations.
Yes.
To say perhaps call as it is, it can be remunerated at 66.7%.
Okay.
This was on the background that
at 66%.
Yes.
Okay.
And BDU had asked for 40%.
Yes.
This was with the privileged information we had from their own 2016 roundabout that they did, a benchmarking exercise across Southern Africa, which their recommendation had said 80. So we said, no, 80, they may not afford, let's just go to 40. And then now the task team for September came in at 66.7.
Yes.
This position paper was then sent to Cabinet.
Yes.
For them to look at it. And
I'm not going to ask you how you got to know about that one.
No, because that is the process. The mandate comes from the Cabinet.
I'm saying how you came to know about whether it was sent or not.
Yeah, well, maybe not. Maybe it wasn't shared. So, but
Yeah.
indeed, they came back and said, well, for specialists, we can give them 2.5%. And then for general practitioners, we give them 5% for the purported 120 hours. So we said, well, that doesn't make sense. It's not even a starter of a negotiation. So let's be serious of things here and understand that we are talking now law here, and you guys are easy to trample on it. Perhaps to make it easier on us, just give us an idea of how you reach the 2.5 and the 5%.
Yes.
That is when they came through now to say, no, let's go back to the mandate giver. They went back, and within a week they came back to say, now that is March, end of March 2023.
Yes.
Yeah. So we are reaching April now, 2023, as your original question. So March, they came back now at the end, like 31st of March. They came back with 10%. We still asked the same to say, how did you reach this 10%?
Yes.
And they said 5% for specialists. And remember that the specialists are not so many. And they do the bulk of the job.
Yes.
They are on call, and they have to continue the next day. Sometimes they do a whole month call, sometimes 2 straight weeks.
Yes.
And then we're like, no, this is disrespectful.
Yes.
So we are going to stop this emergency call thing. And indeed, on the 1st of April, we stopped it. That is when now they went now over the weekend to seek a fresh mandate. And I believe they managed to meet with the then president on a Sunday night. And they came and called us on Monday, the following week, to say, no, we do have now a better offer.
Mm-hmm.
And they called us for Tuesday for a sitting now at the negotiation table.
Yes.
Of which the offer was at 15%.
Yes.
Then we still remain to say, but how did you reach 15% against that which was advised? So this is not what we have as our mandate, because we believe our mandate is quite fair. So they said, no, 15% is the final offer. That is when we inserted the clauses to say, perhaps then let's agree on this 15% on the interim. Yes. Until the 31st of July 2023, whereby you will develop a call contract, which is voluntary. Anyone can sign in or sign out, because it didn't represent fairness. Then
let's park it there for a minute.
Okay.
Let's go for a short break. When we come back, we'll take it from there and move the conversation forward. Let's go for a short break. When we come back, we'll continue our conversation with Dr. Selema. Welcome back. When we went to the break, Dr. Selema, you were telling us that in 2023, there was an agreement that there will be a 15% commuted emergency call allowance. And there were 3 conditions that were attached to that agreement. Can you now take us through that?
Yeah, so in fact, there were 4 conditions. The first condition was that there shall be a call contract.
Yes.
Which was voluntarily, so that anyone can decide if they want to stay on, because we really believe that was slavery terms that we had to agree to. 2, there was also a call policy that now would guide how a call should be done.
Yes.
Then the 3rd one, there should be a schedule for rest.
Yes.
Yeah, and then the last one would be that they develop call rosters. Yes. That will now schedule people and see exactly legally how they schedule those people, so that we don't trample on laws of rest as well as the Employment Act.
In that agreement in 2023, it was supposed to go up to July, if I'm not mistaken.
Yes.
What then caused the delay so that we are in 2025? Your complaint is still that we don't have the call contract, we don't have the call policy, and the other two conditionalities that you spoke of? What has been the major impediment?
No, I think perhaps the government then went into jubilation and celebratory mode to say, well, we got it, it's closed. There is nothing from there that we still need to really work hard on. They deliberately disregarded the conditions that were set. And it must be understood that from the rules of engagement that we had set, that anyone who varied from the conditions that were signed as a collective labor agreement would have then nullified the whole agreement.
Yes.
So by the government party not coming to the party to develop and agree on a core policy contract, schedule for rest and call roster, then essentially they nullified the whole agreement. But to them, it did not speak to that. To them, it spoke to say, yeah, we have agreed, and then this 15% is there to stay, and you do as many calls as we say. If we say you do call every day, you have to do call every day. So then we were like, no, that is not it. Hence wise, on the 2nd of August, we instructed our members again to say, you know what, abandon this thing. This is not what we agreed. And this government, we know, is going to vilify us, and they are going to do whatever. They can go to court. And we wanted now the court to integrate now call into part of work. And it did very well to say, no, call is part of work, and it should be done. And then we asked our members to say, no, now let's go back to doing call. We then went back to the negotiating table.
Yes.
To say, we have instructed our members to go back and do call. Now, can we also find ways to close down the matter? The matter was referred to labor, district labor commissioner,
Yes.
who then sat down with the matter for almost 4 or 5 months or so. And in March, he issued a certificate to say, well, you guys have failed to really agree on anything because the government refused to go to arbitration. And then he sent back the matter now to the negotiating table with the closure of the matter to be done in April of 2024, of which still we failed.
I suppose after that 5-month mediation at the Commission of Labour, that is what then led to the court case that resulted in an interdict issued against yourselves.
You mean the recent interdict?
No, the previous one in 2023, if I'm not
Yeah,
mistaken.
no, the interdict was initiated in August and it was closed in August of 2023.
Okay.
But then we had already referred the matter to Labour.
To Labour.
For mediation and for furtherance into possible arbitration. But then the mediator sent back now the matter in March or so of 2024 back to the table. At that point, we had already instructed our members to go back into the slavery terms, to say, no, go ahead, let's do call as we used to. Of course, they were unhappy. They felt we cut an undercut deal. There was an agreement that they didn't understand, But we were genuine to say, okay, no, let's go back to work. Hopefully these guys now, they will come back and understand that we are trying to as much help them.
In the 2023 case that we are talking about, Dr. Selema, there is a mention that doctors, in terms of Section 46 of the Trade Disputes Act, you are designated as essential service workers. What does that mean for you as doctors?
Well, essential service simply means you are so important that your service is needed by the nation and is life-saving.
Yes.
Yeah. But it does not mean then you are a slave to the government.
Traditionally, if you are involved in the collective bargaining cycle, you would have strike as an option to go to in terms where there is a trade dispute and you can't find recourse. Where do you then find recourse if you're an essential service, as Section 26 of the Trade Disputes Act precludes you from going on strike? Where do you find?
The recourse should actually come from arbitration, because you can't allow these people to go on strike because you have barred them by the law. You can't allow them to do any action that is short of a strike because you have barred them. Therefore, the easiest and most smooth way to do it would not be the industrial court, you see.
Yes.
It would rather be an arbitration process where now you are saying, let's call in an independent arbitrator. Let us talk this thing out. Let us close this matter. Otherwise, then, if you don't allow these people to go to arbitration, then essentially you are furthermore trampling on their own rights as employees.
Then it brings us to this, because Convention 87 of the ILO, which has been domesticated, as a consequence we have Section 46, as we have stated, is the one that, one, establishes who is an essential service employee and who is not, and what legal recourse they can get. In the recent weeks, there's been a back and forth between yourselves and the Ministry of Health and the DPSM as a collective, where they are saying you are now engaging in illegal industrial action. What is your response to that assertion? Because as I was reading your press releases, you were very adamant that no, our people are not on any industrial action that is precluded by law.
No, indeed, our people are not on any strike, nor any industrial action. They're just working standard hours that, one, they're being paid for, and hours that allow them to actually get the rest that they deserve. You must remember that there are maximum number of hours that any employee must work for a week.
Yes.
Yeah. So now if you pass those hours, you must then give that person enough rest for those hours that they worked.
Yes.
Now if you are denying them the hours of rest and also you're making them to work longer or excessive hours, then when these people say, no, let's just work according to the law, are they really wrong? We don't think they are wrong. We think their demands are actually fair, and they're actually what the International Labour Organization would also recommend. Otherwise, then it becomes like this is servitude, and they are coerced or forced to actually take up the work.
Maybe let's take it closer to home.
Yeah.
A tired doctor attending to their client.
Yeah.
What does that mean to me as a patient who walks to go and see Dr. Selema? He's tired, he's overworked. What does that mean to me? And I do so unknowingly.
Yeah, it just means substandard care. And because maybe we are so used to the substandard care, we don't even realize that this is substandard care. So you feel privileged maybe as a client who has been waiting for 5 hours that finally a doctor is coming on the 6th hour to see you. But this doctor is wasted. He's not going to apply himself. He's not going to do the very best that he can do for you. And if it ends up leading to this doctor doing a major operation of whatever sort, then complications are likely to arise. Not from medical negligence by the doctor, but because you really are exhausted. Your mind is exhausted. Your reaction time is exhausted. Perhaps bleeding is going to be increased in that person. That increases the morbidity for that person. So now you look at it and you say, a tired doctor is a hazard to the patient, and it's a hazard to the healthcare system. A lot of our litigation cases that the Ministry of Health would have, they are essentially coming from tired individuals. They are tired during their normal working shifts. They are tired at night. They are just exhausted because of a lack of rest. Therefore, it leads to what? It leads to very poor documentation and substandard care. Hence why you see a lot of medical errors in the country. Most of them, they do go unrecognized, and most of them are never litigated. And I can assure you, if any lawyer wants to be rich, They just have to go to medicine. And
Don't give me ideas.
well, that actually is the best idea that you can get. Forget about human rights and any other things. Just go to medicine and get loaded there.
But basically, what you are saying is the argument by government that you need to return to the prevailing circumstances it's a self-defeating argument, because they are saying they want to offer the best medical care, but you are using people that are exhausted and cannot fully apply themselves at that point in time to their job.
When you go in a new government, there's a lot of excitement. It's like when you're walking into a new relationship. There's just, flying happiness everywhere. And then people fail to realize that there has been life that has been lived or that continue to be lived. And the realities of that life must be realized and incorporated into the new whatever structure that is there. So, of course, the new government will come up with their own flyers, manifestos, we want to do this and that. But the first thing that they should do is really to sit down and analyze that which they find in each department and ministry to say, well, is what I'm finding going to make my manifesto achievable? Let's say, for example, they're talking of medical aids for everyone, national health insurance, universal health coverage.
Yes.
How do you achieve that when you don't have human resource capacitated? When you don't have nurses and doctors who are willing to do that? How are you going to achieve that when you don't have trained specialists to help you achieve universal health coverage, which essentially speaks to, when you are in Hukunzi, you want to see a general surgeon. It should be as accessible as someone who is in Gaborone. Do you think that is achievable when you still have less than 5 Botswana general surgeons, you see? So those are some of the things that the new government, when they walk into the palace, they need to first understand, are my goals going to be achievable? And how do I ensure that these goals can be achievable? First, you need to clean up, motivate the staff, get the staff aligned with you. Otherwise, you are not addressing anything, you're pushing your mandate.
I take it that the health minister did not do himself any favors with his comments at his press conference a few days back.
You know what? When you have a minister laughing throughout the conversation, then you get worried. I think you saw the president. He wasn't laughing when he was simultaneously addressing the people because he's concerned. He knows that this is getting out of hand. I don't know if the minister is aware of that, but this is getting out of hand, and I don't see if the government is seeing it the way we are seeing it. Because if doctors are resolute to say, whatever the legal recourse there, we are right with what we are demanding, how else then do you find common ground?
In your opinion there, where does the problem lie? Does it lie with the political leadership, or does it lie with the technocrats who are supposed to provide the technical counsel to politicians on these issues so that they can also give their 2 cents to resolve these issues? Because we elect political leadership to make decisions for us, to correct things that we see are wrong for us. Where does, in BDU's view, where does the problem lie?
Initially, of course, we very much believe that it is only the technocrats who are having challenges to really lead this matter. But now it is becoming apparent that perhaps the leadership in politics, they don't have that zeal to close down the matter. Because the technocrats get an instruction and a mandate from the politicians. So if the politician is not going to be fully capacitated, either by himself or understanding, Honorable Minister of Health is a medical doctor, so he should capacitate himself. And we have capacitated him personally and as Botswana Doctors Union. So he should be now at a position where he capacitates his cabinet fellows to say, hey guys, my ministry is undergoing a lot of issues, and we need to quickly resolve this. So to me, it's not anymore about the technocrats, but also the politicians who say, where are you in this mess? You are the ones now who are going to have to answer to the public when this now really gets out of hand.
All right. Let's go for a quick break.
All right.
When we come back, we'll move towards wrapping our conversation up and talk about the current case.
Yeah.
We'll be back after a short break with Dr. Selema of the Botswana Doctors Union. Welcome back to the show. I'm still with my guest, Dr. Selema, the president of Botswana Doctors Union. Let's move our conversation forward. As we speak today, there is an ongoing case between yourselves and the government, and it is very reminiscent of the one that you alluded to. Can you explain to the viewer what are the issues before court this time around?
Okay, the issues before the court are that the government is seeking to interdict the action that we took to say 1 call per doctor per month. And the government is saying that that action is industrial action or is an action that is short of a strike. And they actually call it a strike. So to them or to us, we are saying, no, we are not on strike, and what we are doing is in no way defeating what the law prescribes. And then the government now decided, no, this is getting out of hand. They wanted now the interdict. And they have gone ahead and got a rule nicer on the 18th.
Yes.
Now they go through with the interdict, which essentially spoke to say, you, or as BDU, we are not supposed to incite our workers to go on strike, and we should not instruct our workers to abandon any form of work, and that we should instill to our members that they should go in and do that which is appropriate. So indeed we did that. We went on and informed our members that please do not do anything unlawful. Go ahead and continue to do the 1 call per month, and then do not do anything over, because if you do anything over, your contract of employment is not in any way saying you should be doing voluntary work. You have signed a contract of employment which speaks to you getting remunerated for the work that you're doing. If then you decide to do any voluntary work, then it's okay, you can go in and sign your different contract. Yeah. So then now, currently the court case is ongoing, as we are all aware.
Yes.
And the judge has made his ruling on it to say so far, continue doing call as, or the government has got that interdict.
Yes.
But we have also replied, as I just said. And then now, where we are, the points or the
maybe
points.
Before we move forward, just a brief synopsis of your answer to the government's case. What is your answer in short to the government's case?
Our answer in short is that government is trying to promote slavery. Yes. By us, or by asking us to continue to work over the required amount of hours that any employee must work. It contravenes the laws of the country. Yes. And therefore we have said, no, we cannot contravene any laws of the country. Then it's back to the court to interpret, to say, by what government is asking, is it lawful or unlawful? So that's the synopsis of it, really.
Okay. Then it takes us to the issue of collective bargaining, because eventually at some point you have to sit down with government, whether there is industrial action or there's no industrial action. You have to sit down and have a conversation. What does this mean now, going forward, for Botswana Doctors Union in terms of the collective bargaining process? How then are you going to carry out that process?
Now remember, BDU has always been ready to engage the government.
Yes.
Even now we're still ready. Even our lawyer yesterday had proposed that the judge can look into it and perhaps make a ruling to say Section 20, subsection 1E be adjudicated or be given,
invoked.
yeah, or evoked. But the government still did not accede to it, did not consent, which means the government does not want to negotiate cohabitation. So then it means what? Which structure then should we use if the government does not want arbitration for essential service workers?
I guess this now takes us to Section 50 of the Trade Disputes Act, because under that part of the Act, it speaks to collective bargaining under essential services.
Yeah.
And it gives two parts. The first part is that if you have a dispute with the employer over what will be called a dispute of interest, that matter has to be referred for arbitration. And then if it's a dispute of right, it has to be referred to the industrial court for adjudication. Maybe someone at home might be wondering, why hasn't the Commissioner of Labor, in this case, exercised his power to say, this is the type of dispute? Because when the commissioner will then have to make a determination whether what you're fighting for is a dispute of right or a dispute of interest.
Yeah.
In my considered view, it's a dispute of interest. So one might wonder, why then haven't we seen the Commissioner of Labor directing that both parties go for arbitration to save yourselves and the nation the headache of an ongoing conflict, which now we can say it has been going on for 2 years, but from the background that you have given, has been going on since 2012, 13, thereabout.
Yeah. Well, I wouldn't understand. Even we had asked the commissioner at the time that, why are you not exercising your right or your power rather to refer this matter this way? But the government was well informed to say, no, we will only go there if we consent ourselves.
Yes.
And so they did not consent.
Which
Now bring us back to this position to say, well, if the government is unwilling to close down the matter, perhaps they should stop this perpetuation that they're going about to say Doctors Union is unwilling to close the matter. No. Doctors Union is always ready at any point. And they know that even if they write a letter at 12 midnight for a meeting at 1 a.m., Doctors Union will be there within that hour. So what they are saying is actually misleading the nation, and it is what you get when people are trying to maybe protect their jobs and be in favor, whatever sort. But this now goes back to the nation to say, who is accessing these services? The ordinary person out there is the one who's getting affected by this. And if we are not agile and very much resolute to resolving this matter, it is going to go out of hand. And we are not going to be apologetic, and we are not going to be remorseful anymore to the situation. We have done so for many years, and we have killed so many professionals and their dreams and their family and social lives, because we have always put medicine before ourselves.
it was alleged in the press conference by the Ministry of Health. I think it was the Honorable Minister, but our viewers can go relook at that press conference. Yeah. It was alleged that as the Doctors Union, you are playing a zero-sum game. You are saying it is our way or the highway. How do you respond to that? I haven't seen your response in public to that assertion. maybe let me grant you this
Well,
opportunity to react to it.
I think the fact that the minister is not part of the negotiation process and he comes out saying that it's nothing that I have to respond to, because then he's hearing things from other people that, okay, they were saying this. So he cannot come out and say the doctors union are saying this. No, we have met with the minister. We have given him multiple options to say, perhaps consider this. And we were waiting for them as the government party, DPSM, to say, this is what we have. They have not given anything to this date, nothing.
Are you at liberty to share the options?
The options, yeah.
That you put before the minister?
Yeah, we were saying to the minister, look, we have told your team that, look, everyone in government is getting paid for the hours that they work. Beyond, there's a case law, in fact,
Yes.
from AG, DPSM versus Botswana Nurses Union,
Yes.
which simply says over and above the Nurses Union's 30% or the nurses' 30% of overtime, any hour above that, they should be compensated for.
Yes.
And some are being compensated for that. I understand in other areas they are not. But that is now a law which must be respected. We were saying to them that that is your first option. Just activate the law and pay the doctors accordingly.
Yes.
2, you have an option to give now doctors rest days for the days that they have worked. If somebody deserves 10 days this month, don't wait until end of the year to say we'll give them 10 days, because by end of the year, if they accumulate 10 per month, then they would have 120 days. You can't afford to give them. Then 3, we were saying to them that over and above the rest days, can you look into maybe increasing this allowance, and then we can look where we meet to say maybe offer something. Whatever you offer, it's a starting point for negotiation. But where you are not offering anything, then we can't start any form of negotiations. Then the 4th option was, okay, perhaps you realize that you do have a doctor-patient ratio of 4 to 1,000. WHO recommends 1 to 1,000.
Yes.
That means one doctor does work for at least 4 patients. That is for general doctors.
Yes.
For specialists, it's way above.
Yes.
Because they are short on the ground. So we're saying to them that perhaps then hire more people, that you alleviate the situation, because you don't want to do any of the options. And the 5th option was, please bring your position to us so that we know what you are thinking. But none of that was acceded to. So now if the minister goes on PR stunt and says it is our way or the highway, then it's very unfortunate, very, very unfortunate.
Just to, we are about to wrap up our conversation. It was alleged by one of the assistant managers HR at that press conference too, that collective bargaining only takes place once a year. How do you respond to that very, very shortly?
Well,
because it's made the impression that you only sit at the table once.
That is quite, I don't know the right word to use, but it's very unfortunate, I'll keep saying, that such a senior manager comes to that forum and says that, gives the nation that. So the collective bargaining structure that we had was for 3-year period.
Yes.
That was from 2022, 2023, 1st of April, until the 31st of March, 2025.
Yes.
So in that period, the collective structure stays. If there is any matter that arises from the signed collective labor agreement, it is referred to that structure at any given point. So there is nowhere where it says that collective labor structure sits once a year. There's nothing like that.
Okay.
Yeah.
Maybe the last question, and it's the question that everyone is probably wondering about every time you speak to a union leader. Where are we in relation to the establishment of the PSBC, Public Service Bargaining Council? We have heard what the ministers have to say in Parliament, but in terms of what you know as parties to it and its establishment, where is it? Where are we right now? Because the last time it collapsed, the major hurdle was who can be admitted into it.
Yeah.
Basically, the numbers.
Yeah.
Where are we with that one? Has the constitution been done? Has it been signed, registered with the Commission
I
of
think
Labour?
that one has made some good progress. They managed to change the law, the Public Service Act, so Section 51, which essentially said that consent must be sought in an agreement by all the 9 recognized trade unions must agree that the PSBC be established. So they changed the law in December to now read that the majority, if agree, then PSBC shall be established. So now where we are, the constitution draft has been looked into, the funding model has been looked into. Now we are waiting now to meet with the registrar to go in and register the constitution and the PSBC. So it's going to maybe take 2-3 months before it actually begins to take effect. So in the meantime, I believe you have seen from yesterday's release or today's release that we have now agreed to negotiate for salaries and conditions of service for this year outside of that structure because it's going to take time.
Okay.
Yeah.
Thank you for joining us, Dr. Selema. I think it was very insightful in understanding what your issues are and the laws that govern your ability to carry out your collective bargaining mandate.
Yeah.
Maybe let me give you this opportunity to say your last words to the nation, to members of BDU alike.
No, to the nation, I would just say that they must understand where we are coming from. We are not in any way insightful of anything or any violence or discord. We are actually citizens and employees of the government, and we are actually looking out for the government to implement things that are sustainable and for it to be attractive to the world out there. For specialists, we have qualified subspecialists. They should be staying public. We are looking for healthcare reforms that are going to make health attractive again. So this is just a single step of 1,000 miles. And to the members, I can only say, rest assured, we got this. And to the employer party, I can only say, come to the party.
That's it for this episode of That Fine Bachelor's podcast. We have had this opportunity to learn from the good doctor as to issues surrounding essential services and how they carry out collective bargaining. We'll meet each other in the next episode. Have a good one.